Okay, welcome everybody. I'm Teresa Reed, a member of the Brews and Views Committee of the League of Women Voters of Ann Arbor area. As you know, the topic for tonight is the First Amendment in 2020. Has the marketplace of ideas crashed? Committee of the League of Women Voters. The First Amendment to the U.S. Constitution guarantees freedom of speech, a cornerstone of American democracy. In recent years, however, many people have come to question whether we've gone too far in our protection of free expression. The First Amendment is meant to promote democracy and protect against discrimination against unpopular views, especially state discrimination. But writers like Emily Bazelon, Sue Halpern, Carol Cadwalader, and others argue that the situation we find ourselves in which falsehoods stream loudly from our devices 24/7, is instead detrimental to our democracy. They argue that this noise isn't meant to win any battle of ideas, that its real goal is to prevent the actual battle from being fought by causing us to simply give up in despair and disgust. The classic argument, the remedy for awful speech is more speech, feels weak when the awful speech that inundates us is funded by self-interested billionaires and malignant foreign governments. It seems impossible to counter, like trying to stop Niagara Falls with a squirt gun. As one commentator wrote, we're drowning in lies. How did we get here and where do we go next? We are very lucky tonight to be joined by our guest, Len Niehoff, a professor at the University of Michigan Law School and of counsel to the Honigman Law Firm. He teaches courses in First Amendment, media law, civil procedure, evidence, ethics, and law and theology, and has taught a small seminar in the history of banned books. He's the author of more than 100 articles, many on freedom of speech, and is currently working on books on the First Amendment and the Salem witch trials. He has represented media clients in First Amendment cases for more than 35 years and is a nationally recognized practitioner in the field. Professor Niehoff, welcome.
Thank you very much, Teresa, and thank you and the League of Women Voters for inviting me to join you tonight. Thanks especially to all of you who have chosen to spend your evening dedicated to even more screen time. I'm sure all of you are getting more than enough screen time between Zoom and other virtual platforms to attend meetings and so forth. So I'm very grateful that you've chosen to take the time to do this. It's also a pleasure to see, just on a quick scan of the people in the audience, so many old friends, Nick Rimmel, Debbie Herbert, Tamara Stein. I'm completely mystified as to why these people who know me very well would choose to spend their time this way. The rest of you, I think, are just being optimistic. But in any event, I will try and make you feel like your time has been well spent and that it was worth still more time staring at a screen. So tonight I'm going to share some ideas with you about the First Amendment and about some of the struggles we're having right now with free expression, and about why we actually, I think, are having them now more than ever. And this is not just an illusion. We are, 2020, we can all stipulate, is a special year, and it's special in this respect as well. Now, the law of the First Amendment is deeply complex, and I can't do it full justice tonight. As Teresa mentioned, I teach an entire law school subject, course on the subject. And in fact, the law in this area is so complicated that I point out to my students that the Supreme Court has interpreted almost every word of the text of the First Amendment to mean something other than what it literally says. So this is a dense, complicated body of doctrine that's hard to summarize or do justice to in the short time that we have together tonight. In addition, the evolution of First Amendment law has not been entirely tidy. We can divide the history of First Amendment doctrine really into three eras. But prior to 1919, the Supreme Court interpreted the First Amendment very narrowly, and First Amendment rights were anemic at best. The government prevailed in virtually every case that came before the Supreme Court where there was a challenge based in free expression. As those of you who have visited the National Archives in Washington know, these days, the First Amendment and the rest of the Bill of Rights is on public display, beautifully framed, there for people to look at and ponder, almost like a sacred text. But it was not always this way. And in these very early years, in fact, it's somewhat symbolic that the Bill of Rights was not on display, that it was relegated to storage in a cellar of a government building where it shared space with a collection of Japanese and Haitian swords. The Bill of Rights was figuratively and quite literally out of sight and largely out of mind. Things started to change in 1919. I'll have more to say about that shortly. And from 1919 to 1963, we can see more robust protection for free expression emerging in the Supreme Court's decisions and in the decisions of the lower courts. But it's hard to say that prior to 1964, we really see the robust First Amendment protection that we know now, in part because there were some major doctrinal failures during that era, and some of them relatively late. For example, during the Red Scare of the 1950s, the Supreme Court afforded very little protection to speech that was thought to promote communism, and it upheld many forms of government punishment of such speech and of anything that was deemed to be communist association. So we start to see the doctrine emerging from 1919 to 1963, but it's really not until 1964 that we start to see the development of the very strong First Amendment doctrine that we know today, which grants very broad protection to numerous forms of speech, subject really to only relatively few exceptions, and those exceptions generally being pretty narrowly interpreted by the court. So I like to take 1964 as a turning point because it marks the year of the Supreme Court's decision in New York Times versus Sullivan, which, as you all know, made it significantly harder for public officials to win libel cases against media entities. And we get some language in New York Times versus Sullivan about the country's commitment to robust debate over important public issues. We get some language in that case that really becomes central to our understanding of the First Amendment. And so I think 1964 is a fair date to pick as the date when we really start to see the development of the doctrine as we know it now. And I raised that at the beginning because I think it sort of points out something of a paradox. In a sense, our current First Amendment doctrine, when you think about particularly when we think about how we venerate it, how central it is to how we think of ourselves as a nation, how we think of the whole concept of democratic participation in this country. This doctrine is actually relatively young. Critical parts of it are less than 60 years old. And in the grand scheme of American jurisprudence, that makes it relatively young. At the same time, the doctrine and many of the models and assumptions that it's based on may strike us as old and outmoded and outdated and outgrown. And that is, I think, in large measure because of the central and really eclipsing place that the internet holds in the communication of information and ideas for us today. So tonight, I want to share with you 3 ways in which the internet has, I think, vastly complicated our thinking about free speech and the models and the theories that we use to explain it and to defend it. Excuse me. And I want to do that by reference to three themes. My first theme, which is sort of the title of our discussion, our conversation tonight, is that the marketplace of ideas has crashed. Now, I mentioned earlier that 1919 marks one of the turning points in the history of First Amendment doctrine, and that's because of a dissent that was filed by Justice Oliver Wendell Holmes in a case that year called the Abrams case, United States versus Abrams. And I want to talk a little bit about that case and about the opinion, because this becomes really the dominant theory that we have, absolutely the most influential theory we have for why we protect free speech and why we protect it robustly. By today's standards, we would find the majority opinion in Abrams absolutely appalling. The case involved the circulation of some pamphlets that were protesting United States interference in Russian affairs. Today, we would find the contents of these pamphlets to be harmless, garden variety polemic. And we would certainly not think that the government had the authority to restrict them. To sort of compound the irony here, the pamphlets were actually distributed by the highly scientific and effective method of throwing them out a window to people who might find them or receive them. Hardly the most effective method for communicating a supposedly dangerous idea. And I think we can all agree, unlikely to lead to the prompt dissolution of the Republic. Nevertheless, despite the rather benign contents of the pamphlets and this sort of curious method of distribution, the authors of the pamphlets were charged under the Federal Espionage Act and were sentenced to 20 years in prison. A majority of the Supreme Court in 1919 upheld the verdict. But Oliver Wendell Holmes penned a famous and beautifully crafted dissent that was so influential that sometimes people forget that it was a dissent, that it was a dissent from the majority opinion. And in this dissent, Holmes famously argued that free expression exists primarily in order to facilitate our search for the truth. The best test of truth, he wrote, is the power of an idea to get itself accepted in the market. This is this elaborate metaphor that Holmes starts to develop here. In other words, we have access, free access to ideas and information. Those ideas and information compete for our belief and our allegiance. And through this process, this kind of dynamic process, we find our way toward the best ideas and the most reliable information. Now, a couple notes here. The first is that this is not the only theory for why we have the First Amendment or free expression. There are actually numerous theories. This just turns out to be the most influential one, certainly within the Supreme Court jurisprudence, but I think generally as well. The second observation is that Justice Holmes was not a dreamy-eyed idealist about how well this was all going to work. He concludes his analysis in this part of his dissent by sort of shrugging and saying, it is an experiment as all life is an experiment. But even a realist like Justice Holmes, even somebody who recognized that this wouldn't always work all that well and it was an experiment, as all of life is an experiment, even he could not have foreseen the ways in which the internet would challenge the operation and the underlying assumptions of the marketplace of ideas. And I want to walk through a few of these. You could really turn this into like a parlor game where you sit around with a good glass of wine and try to just sort of figure out all the ways the marketplace of ideas is going wrong these days. I'll just mention a few of them. First of all, the marketplace of ideas theory assumes that we will receive information in a form and in a quantity and at a pace that we can process it. But as we all know, it doesn't work that way anymore, if it ever did. Every day, vastly more information comes over our electronic transoms than we can possibly process. A little while ago, I seemed to have a rather busy day on email. At the end of the day, I did the math and realized that I'd received roughly 80 emails an hour in the course of the day, coming from various listservs and various sources of information and so forth and so on. The huge variety of sources of information also make it hard for us to figure out what's reliable and what's not. There is so much coming over the transom so fast that it's very hard for us to take the time to try to figure out whether what we're looking at is even worth looking at. And the pace makes analyzing the information almost unmanageable. And it tends to incentivize us to look for anything that doesn't require our analysis. We like things that are simple. We like memes and slogans and quips and emojis. These are easy ways to get through the processing of this vast amount of information. So Justice Holmes's sort of assumption that information would come to us at this pace and in this way where we could take it, analyze it, consider it, think about it, debate it, just doesn't hold up very well in the current model. A second problem with the marketplace of ideas theory is that it assumes all ideas get equal access to the marketplace. But again, we know it doesn't actually work that way. Some voices will be amplified, are amplified because of concentrated media ownership or power. Other voices will be amplified because they reflect majority viewpoints. And so more people will repeat them and they will tend to spread in this way. This is one of the great puzzles of our current time, right? There was a time for most of human history, in fact, when there were very few publishers and all of us had privacy. And now everybody's a publisher and no one has privacy. So we get this amplification of majority voices and viewpoints going on, and that ends up distorting the way the marketplace of ideas functions. It's easier to become a celebrity in an environment like this. There are more celebrity voices than we've ever heard or had before. And celebrity voices can be unduly amplified. There are technologies, algorithms that can amplify certain messages. And of course, to the degree that some voices are disproportionately heard, it means that there are some voices that will be disproportionately not heard. There are ideas, perspectives, narratives that will struggle to get into the marketplace of ideas at all, let alone get traction. So, you know, Justice Holmes's sort of economic free marketplace with no barriers to entry ends up not working so well. It turns out there are barriers to entry and certainly inequalities within the marketplace. A third objection that might be raised to the marketplace of ideas theory is that it assumes that everybody in the marketplace is interested in discovering the truth and then sharing it. But as we now all know, if we did not before, this is not the case. It turns out that people have lots of agendas other than finding the truth. They may not care about the truth, and some people may indeed have a keen interest in suppressing or distorting the truth. So the sort of good faith that Justice Holmes imagined in the operation of the marketplace, where people are earnestly trying to find the truth, may not turn out to be right. So here we have this is the dominant model for why we protect free expression, and we see it is deeply troubled. We find ourselves in an informational environment where we receive ideas and purported facts faster than we can process them, in quantities that overwhelm us, with limited ability to assess their reliability, often to the exclusion of minority viewpoints, and frequently as part of an exercise that seems to have very little to do with finding the truth or even caring about it. So, theme number one, the marketplace of ideas has crashed. The second theme, a little bit more complicated and a little bit more technical and nuanced, is that private platforms now trump public platforms. Let me repeat that. Private platforms now trump public platforms. And if you're wondering, my use of the word Trump is indeed a deliberate pun. So let's start here. A central idea within traditional First Amendment doctrine is that every citizen should have the right to express themselves in what First Amendment theorists call public forums. Public forums are those open public spaces owned by the government where people gather to debate and argue. And the Supreme Court has said parks, streets, sidewalks, town squares, these are traditional public forums, the places where people greet each other, meet, argue over ideas, debate the great questions of the time, and we need to have free speech in those public forums. And this model, to some degree, seems a little bit old-fashioned. It's kind of like a maybe perhaps a bit antiquated notion of community organization, where the town square serves as this hub for public communication. But it does continue to play a critical role in free expression. The public protests that have taken place in recent years around movements like #MeToo, Black Lives Matter, the protests following the murder of George Floyd, and so many other people, tragically too many to name. Those protests have all depended on this old and well-established idea. These gatherings that we see in parks and streets and sidewalks, they are protected by this public forum doctrine. So this doctrine continues to play a very important role. And it has evolved a bit to adjust different kinds of technologies. Courts have recognized that a public official may be able to convert a private resource into a public forum where First Amendment doctrine applies. An example of this comes in President Trump's Twitter account. As some of you may recall, President Trump at one point excluded some people from participating in his Twitter feed because they expressed viewpoints and ideas that were critical of him. So he excluded them from his Twitter account. A federal court held this was unconstitutional. In essence, the court reasoned that President Trump used his Twitter account like a public square to do public business, and therefore he couldn't exclude participants based on their viewpoint and their speech. So public forum doctrine matters a great deal. It protects our right to do public protests, and it has been, by the courts, shifted to address some of the technological changes. But having said all of that, First Amendment doctrine faces a very serious challenge in online platforms like Google, Facebook, Twitter, YouTube, and the like. And here's why. As Teresa mentioned at the beginning, the First Amendment only prohibits the government from abridging free speech. It does not apply to private actors. Private parties are free to infringe free speech unless some law other than the First Amendment prevents them from doing it. So if I say something in the town square that the government doesn't like, it can't order me to shut up and go home. On the other hand, if I say something in the living room of your house that offends you, nothing in the First Amendment prohibits you from showing me the door and telling me not to come back. That's the structure of the First Amendment. It limits what public actors can do, but not private actors. It limits what the government can restrict in public forums, but not what private parties can restrict in private forums. Now, the problem with that structure is that it is now, I believe, completely clear that private platforms have largely eclipsed public platforms as vehicles for free expression. For every gathering that occurs at a public park to protest, there will be hundreds of thousands of tweets, Facebook posts, and Google searches. If you're looking for the town square, you wouldn't get in your car and drive around town looking for a physical space. You'd probably actually go looking online. That's where our public squares largely exist today. That's where most debate and communication happens. Now, the reason that's so problematic is that although the government can't control the marketplace of ideas because of the First Amendment, private platforms can and do. When we talk about something trending on the internet, we're not just describing the result of organic popularity, of the natural play of the marketplace of ideas. Instead, what we're describing is the result of the application of multiple algorithms and manipulations that put certain ideas and information in front of us, return it to us, keep it in front of us, spread it. And this dynamic creates a very serious dilemma. As I noted, these private platforms don't have any responsibility under the First Amendment, like the government has responsibilities under the First Amendment, because they're not government actors. In fact, not only do they not have responsibilities under the First Amendment, they have rights under the First Amendment. In a sense, these platforms are no less publishers and distributors of information than are the New York Times, the Washington Post, or your local bookstore, all of which obviously receive the protection of the First Amendment. So this means that any restraints the government imposes on these social media platforms, and we have executive orders now from the president that have tried to do some of this, actually threaten the First Amendment rather than promote it. But it gets more complicated because, of course, the public can, and these days often does, put pressure on these platforms to self-regulate. For example, to delete content because it's hateful or because it promotes a debunked conspiracy theory or something along those lines. But the fact that these media platforms are responsive to public pressure is a problem in and of itself, because it means that these platforms become subject to the will of the most vocal majority. So for example, if a majority of people think that Twitter and Facebook should censor speech by the Antifa movement, then those platforms may bow to that pressure. But that's exactly why the First Amendment exists, in order to prevent the majority from determining what the rest of us can hear and read and consider. Indeed, the First Amendment, like the rest of the Bill of Rights, is an anti-majoritarian idea. The majority doesn't even need the First Amendment because it will not pass laws that censor its own viewpoints. The First Amendment has always been about protecting minority viewpoints from the control of the majority. But if now most communication happens in these online platforms, and if they are subject to majority pressure, then we have a serious, deeply worrisome First Amendment problem. Okay, my third theme is that we are struggling now more than ever to figure out whether free speech is an ally or an enemy. This was hinted at to some degree, I think, in Teresa's introductory remarks. You know, a few years ago, two leading scholars wrote a book regarding free speech on college campuses, Erwin Chemerinsky and Howard Gilman. Really a very good book. And they noted that recent surveys showed that current college students don't treat free expression with the same sort of reverence and veneration as prior generations. That they noted that the current generation of college students are much more comfortable with the idea of government restraints on speech, especially hateful speech and speech that minority groups find offensive. And the authors offered a variety of explanations for this development. They suggested that this current generation of college students are the first generation to have received a K-12 education that focused on the problems of bullying and the evils of bullying and the harm that words can do. And they also noted that current college students didn't witness the important role that free expression played in the 1960s in advancing the civil rights movement and in empowering women and minorities. And both of these observations are true. The first observation, I think, has grown even more true. It is no longer just the case, I think, that college students are the ones who are concerned about the impact of words. There's an increasing body of scholarship, including work by what people I would view as sort of traditional First Amendment scholars, trying to deal with this concern about the harm that speech does, and the fact that that harm is not equally distributed. It's all well and good for us to talk about this valuable principle of free speech, but the fact is that the costs of free speech are not felt equally and experienced equally by all of us. The costs of free speech fall disproportionately on people of color, on members of the LGBTQ community, on women. I think it's a legitimate question to ask whether our First Amendment doctrine goes too far and doesn't do enough to protect those who end up bearing its costs disproportionately. Interestingly, their second observation about protests, I think, is no longer true. The murder of George Floyd and the protests that arose during the summer are, by some estimates, the largest protests that have happened in the history of the world. And so we now have students, I think, who not only can see the value of free expression, but are participating in it and even leading some of these efforts. So, I think we have a very complicated picture in trying to figure out, well, how do we feel about free expression in the current environment? Is it actually this structure, this legal structure, this piece of legal architecture that ends up being weaponized against minorities and against women and against people of color and various other groups? Or is it actually the key to our freedom and our liberty and indispensable and something that we need to protect precisely because it advances the interests and the rights of those individuals as well as everyone else? I've been talking for a long time. I really want to get to your questions. I will close before we go to questions with just this thought, and then we'll share some other ideas. But just as Holmes said, this thing that we're doing here, it's an experiment, as all life is an experiment. And I think it's always fair to call the question of how well the experiment is going and trying to figure out whether the experiment is right and has the right protocols, or whether we've messed something up along the way. Because after all, if we cannot defend it, we should not continue to do it. And so, I think this is where we find ourselves in sort of complicated First Amendment territory. I have some ideas about where we go next or where we might go next. This has largely been a critical, deconstructive presentation. I actually do have some positive and constructive things to offer as well, if anybody wants to hear them. But I think at this point, having spoken for so long and you all being so patient, the best thing to do might be to go to your questions and see if I can field them in a way that feels responsive and helpful to you. Teresa, I think you're muted.
Okay, good. Thank you, host. Okay, so thank you, Len. That was really informative. I hope you put your questions in the chat as they come up. I want to ask you about a few, actually about 100 things. But let's start with one of the problems that we are experiencing now. And that is the fact that we're engaged in asymmetric warfare in this marketplace of ideas. By which I mean, Well, I started with the metaphor of trying to stop Niagara Falls or even have any impact whatsoever on Niagara Falls with a squirt gun. Um, Fox News is hugely funded by an Australian billionaire and then amplified over Facebook many, many times. And as we know, and you referred to the fact that because of the overwhelming flow of information in our direction, and this is well known, we we go for what's fast. We go for what seems to be easy to pick up, and and what is familiar. So how what kind of allowable remedies are there to this massive, and there's an entire, as you know, right-wing ecosystem of websites, and I mean Breitbart News and Fox News and then amplified by Facebook and other outlets, that OANN, Sinclair Broadcasting, all of which amplify each other. So what are some allowable ways to intervene in that ecosystem?
Yeah, that's I think one of the most important questions and greatest challenges that we all face. And there's an old adage that for every hard question there's an answer that's simple, straightforward, and wrong.
Yeah.
So I have suggestions, but none of them are simple or straightforward. One of them, I'll offer a few thoughts up. One is that, a lot of content today is freely accessible to it and to us, and we read it and we circulate it and we share it, and but we don't pay for it. And newspapers across the country, media entities across the country are engaging in budget cuts, and budget cuts very often with respect to investigative reporting. The most expensive. It's not expensive to put out a newspaper if all you do is have a gardening column and reprint what the AP circulates and so forth and so on. You still have to figure out an advertising model, but to really put out impact journalism, you have to be able to do investigative journalism, and that's expensive. That means I take a reporter or two or three or a team, and I put them on a project, and they spend months, focused largely on that activity, and that costs money. And we are all doing a lot of free writing, to be perfectly honest.
Yeah.
And so I think one of the things we can all do is identify news sources, whether it's NPR or the Wall Street Journal or the New York Times or the Wall Street, whatever it is that we think is where we followed it long enough to have some confidence in its reliability, and invest in those invest in those entities in order to empower them to help the marketplace of ideas work more on a more even keel. So I think that's really important, but I also think it's very hard to get away from individual responsibility here. 20 times a week, I read somebody on my Facebook page or somewhere else basically saying somebody needs to do something about this. And I'm not sure who the somebody is that they have in mind when we are all doing this. We are all participating in this marketplace. We are thoughtlessly spreading information that we don't investigate. We are reflexively spreading links without actually reading the article. I'm sure we've all had the experience of watching our Facebook page where somebody pops up an obituary saying, "Oh, I'm so sorry that such and such a person just passed." And if they'd looked at the obituary, they would have said they died 5 years ago. We're just individually, I think, not taking enough responsibility for the way in which we all participate and all contribute to the problem that we're describing. So I think, two very simple things we can do immediately invest more in those media entities that we believe in and exercise greater responsibility in the way that we participate ourselves in the marketplace of ideas.
Okay, I'm sure that that's true that we can do that, but there are obviously systemic issues. I mean, here's an example. So everybody has heard about the discredited story about Hunter Biden's computers that mysteriously fell into Rudy Giuliani's hands and so forth. And that whole story, which even Fox News passed on. So it was hand delivered to the New York Post, and then and almost immediately seen as illegitimate, because nobody, the actual author wouldn't put his byline to it. But then, because it was in the New York Post, it was talked about on Fox News, flogged on Fox News, really, for 5 days. And then one of the Fox News hosts published an opinion article in the Wall Street Journal about that. So that gave more fodder for the conversation on Fox News. And one of the salient characteristics of all of those outlets is that they're all owned by Rupert Murdoch. So as I sent you something about the Royal Commission in Australia that's looking into examining Murdoch's impact on their democracy in Australia. And so individual actions in the face of that kind of systemic offense, really, assault on our communication system feels a little weak. So I'm wondering what else we can do. I mean, about the fairness doctrine and all of the ways in which the US government attempted to make newspapers and radio, especially when radio was new, to make it serve democratic purposes. So can we reinstate that kind of federal policy to protect to try to put back together our marketplace of ideas?
Well, I am not a big fan of the fairness doctrine. I think the fairness doctrine actually created some dreadful incentives to stay away from public interest reporting altogether. The easiest way to have to tell both sides of the story is to tell neither side of the story. So if what you want is endless news of cat videos, then I think, resorting to a doctrine like that's a terrific, strategy. But so I think, Teresa, I'm gonna resist the idea that Fox News is itself a systemic evil. I mean, the problem with the systemic problem, if we were going to identify one, is that we have a largely unregulated marketplace. And that's what allows something like Fox to achieve the amount of market power that it has, right? And so that means that's the systemic, if there's a systemic problem, I think that's what the systemic problem is that the marketplace is unregulated. And so that basically leaves us with two alternatives. One alternative is you leave the marketplace largely unregulated and you do the best you can with the consequences of that. Or the other is that you try to start regulating the marketplace. You start breaking up ownerships when they achieve a certain level. You make it easier to sue bring certain types of claims, those types of things. The problem when you do that, as you move toward, and let me be absolutely clear about this, reasonable people can disagree about this. Reasonable people can say, I think an unregulated marketplace where we all just, take our lumps but sort it out, that's the way to go. That's, I think, a reasonable position. People who say we need more regulation, we need to do more, I think that's a reasonable position. The problem with wanting more regulation is you have to figure out what it would look like. You have to be sure that it's not going to be vague, it's not going to be overbroad, and you have to be sure that you're willing to live with the consequences for the speech you like. Because the First Amendment has a dreadful symmetry to it. Whatever you suppress on one side, you're going to end up suppressing on the other. So if you want less right-wing political diatribes, you may be able to get it, but you're going to get fewer left-wing political diatribes at the same time. And so I think, you know, could we do more? In incremental ways under existing law, there are some additional things that can be done. I think they're limited under existing First Amendment doctrine. But I think in each case, what you have to do is talk about what you want to have done and whether you're going to be happy with the consequences. I was speaking at one of these panels and somebody said, why can't we just regulate hate speech? Hate speech would be the easiest law in the world to write. And I said, we're going to take a 15-minute break in just a few minutes. Write me a hate speech law that's going to punish everything you want to punish and nothing you don't.
Yeah.
And so, you know, it's very easy to talk about how we want to do more and we want more regulation, but you got to figure out what exactly you would want to do, and you have to be sure you're going to be willing to live with the consequences it means for the speech you like.
I have one more question about this, and I want to get to some other questions that are popping up. But what about the regulations that we used to have until the 80s or so about, for instance, media concentration in a single market, so that you know, the same entity cannot own radio and television and newspaper in the same market? I mean, that seems reasonable. That seems like that would be fine.
Yeah, I think, you know, with antitrust enforcement,
Right.
you know, that's an issue that people can look at and try to figure out whether they want more antitrust, you know, they want antitrust enforcement. One of the things to understand is as the economic model for media entities has become more and more challenging, one of the ways in which media entities make up for that is by either being purchased by a company that's not a media entity at all, or by joining with other media entities for consolidation purposes. So if you really strictly enforce ownership laws, whether it's ownership by non-media entities or it's ownership by, you know along in the anti-competition, antitrust way of going about things, if you make those choices, one of the things you have to realize is that you're eliminating some economic alternatives to media entities that are already struggling, trying to figure out how to put journalists in the newsroom and on the streets.
Mm-hmm.
So, you know, yes, you may break up, you know, you may break up some of the sort of the larger entities by doing that. But again, you have to ask whether you're going to be happy with the consequences across the board.
Right. So no solution is cost-free, but weighing, you know, the incredible damage that the current situation is doing to our democracy with the, you know, costs and benefits of possible solutions is an important task right now.
Yeah, I think that's right. I mean, I think that what the question has to be, what specifically is it that you would want to do? And then what are the costs that are going to follow from that? And are those costs, you know, worth it? What's the cost? What's the competing cost to our democracy?
Right.
Because, you know, you can have a pre-1919 model. You know, we can have a model where we send people to prison under the Espionage Act for 20 years for throwing a leaflet out a window. There we had things under very tight control.
Yeah, yeah, but I mean, it was we had the you know, we had the restrictions against media concentration, ownership concentration until the 80s. I mean, it wasn't, and things were going pretty darn well.
Which is an interesting fact, because of course whether you can show actual market control now is harder, because the most important democratizing force in the history of human communication, which is the internet, came on the scene. And so trying to prove control over information when you're a publisher, I'm a publisher, you know, you have bloggers where you have where the dissemination of information is now much more diffuse than it used to be.
Right.
To show concentration is also much harder than it was in the pre-internet era.
Yeah, it's interesting. Complicated. One, as you said, it's very, very complicated. So here's a question. It starts with a quote. This is from Larry. If you are not paying for a product, you are the product. How can the Supreme Court decide money is speech and therefore companies with huge money are entitled to huge speech? Right. So this isn't, well, I'll just let you jump into that.
Yeah, so so I think that there's been a lot of discussion about getting the Supreme Court precedent reversed, and trying to address campaign finance law, and trying to fix the Citizens United result. A lot of the frankly, a lot of the conversation around this, it's a very good question. But like many important, complicated issues, a lot of the early conversation around it got kind of silly, and frankly didn't do us any favors. Long before Citizens United, the Supreme Court had recognized that entities, that corporations and other legal entities had First Amendment rights, that they could speak. And if you think that only human beings should have First Amendment rights, then be prepared for the conclusion that the Sierra Club doesn't have First Amendment rights, and your union doesn't have First Amendment rights. We either give entities a right to free expression or we don't. And so the idea that a corporation, or that corporations had a right to free expression, was in and of itself completely unspectacular when Citizens United was decided. And a lot of the rhetoric around it made it sound like this was some big revolutionary development, when in fact it was completely consistent with what the Supreme Court had said. Now, money is more complicated, because there obviously is a sense in which money is a way in which we express ourselves. We support organizations. What's the first thing I said to you, right? Express yourself by getting a subscription to a newspaper that you think is so we speak with our cash, just as we do with in many other ways. The fact that it should be noted that just because something is speech doesn't mean it's absolutely protected. The fact that cash is, or that money, or that financial contributions can be speech, doesn't end the conversation. It actually just sort of continues the conversation, because it means that once we deem it to be speech, it means that there are some controls that can be exercised over it. It's just harder to exercise controls over it. And so if you really go back and read the Citizens United case carefully, what is to me relatively clear from the case is that the problem was that the standard couldn't be met for showing that the speech should be regulated in the way that the regulations were restricting. And that's a question of how much evidence you can assemble, how Congress can frame a law that tries to get at this issue. There are lots of ways in which a post-Citizens United conversation is possible, but it takes place, that conversation has to focus on what are the things that we can show in terms of the distorting effects of large contributions, the natural corrupting consequences that flow to our democracy, the corrosive effect. How can we document these things, prove these things, in order to support federal regulation to restrict them? That's a heavy lift, but it's not impossible. And the conversation isn't foreclosed by virtue of the fact that we think that that money is a form of expression. So, I think this is one of those public issues where I remember reading competing op-eds in the Wall Street Journal between two people about whether corporations are people. And, I think it was Jack Welch was one of the people. I think Elizabeth Warren was the other one. And Elizabeth Warren was saying, corporations aren't people because they don't take their kids to soccer games. And Jack Welch was saying corporations are people because what else would they be? And here you have two very smart, very competent people basically talking gibberish about an issue that's of tremendous public significance. This isn't about whether corporations take their kids to soccer games. This is a much more nuanced and complicated conversation like that. And when we
Right.
have that kind of public dialogue about it, it's just a shame.
So I'd like to know, what the possible, first of all, it seems like we have a lot of documentation already, of pretty good documentation, I think, of the impact of unlimited money on the political system. I think that there's a great deal of evidence of its harm. So that feels like that lift has been pretty well taken care of. But a related issue, and you'll have to tell me if this is, I don't know if this is part of Citizens United or where this comes in, but the fact that the sources of the money do not need to be disclosed, the dark money problem, because that also seems to me like, I mean, then it feels almost like shouting fire in a darkened theater, like, because the identity of the speaker can't be determined, but it causes pandemonium. So maybe that's not a good analogy, but if the identity of the speaker is cloaked, what's the value of that? And why can't we, what is the possible negative impact of uncloaking?
Yeah, so I'm not an election law scholar. I don't teach election law, I don't write about it. And so we actually get pretty far away from things I can talk about sensibly as we get into the details. What I can say generally is this. I say to my First Amendment students at the beginning of the term, look, there's a dynamic that happens over and over and over again that gets laws struck down that try to regulate speech. And it's kind of like a Newtonian principle. And it goes like this. For every action, there is an unequal and opposite overreaction. And we see this happen all the time in legislative responses to evils. We identify something that seems to be a problem. The bigger the problem, the bigger the solution it seems to call for. And so the legislative solution that is drafted is big and comprehensive and wide in scope. And then when a court looks at that and applies a standard like strict scrutiny to it, the court says you acted too broadly and the law gets struck down. And this plays out over and over and over and over again in First Amendment cases. It's a completely predictable dynamic. Mm-hmm. So although I'm not knowledgeable enough to get into the details about dark money, and this is not outside the things I think about. But what I can tell you is that, I think that campaign finance regulation generally has been true to this model. There have been legitimate concerns that have been identified. The legislative responses to them have been overly broad, and that has made it easy for the court to strike them down.
Okay, I hear you that you're not an expert in this area, so I'm not going to push it. I'm just going to say that it seems like a simple fix to say the sources of the funds cannot be secret. That should be public information. That seems kind of easy to me. So I just
well, let me make it, it's not my area, but let me make it a little more complicated for you.
Good, thanks.
So we recognize that there are instances where we want people to be able to speak anonymously. And there is a body of Supreme Court cases that actually say there is importance in this principle of anonymous speech, and that through anonymous speech, we actually promote information. We get ideas into the marketplace that otherwise wouldn't get there. There are rights that are advanced and causes that are exposed because at the beginning, people have to speak anonymously. And so we have a principle that there is some value in being able to speak anonymously. And when one of the early techniques that was used against the NAACP was to try to get them to disclose membership lists.
Yeah, right.
In the South, so that those people would be harassed and might lose their jobs and so forth and so on. So if we don't care about anonymous speech at all, it is an easy fix. But if we think that donations are a form of expression. And if we think anonymity can matter in these cases, then we might want to protect it.
Very helpful. That's very helpful to think about the value of an anonymous speech. I still think we can get around that, but but that's really, really useful. Hang on, I want to look at some questions. Well, let me look at some questions in the chat. Here's from Christine. She says, I think where we have gone wrong in the television media is in the 1980s when the news moved from a public service to an entertainment division designed to make money and required to earn high ratings. I think in that transition, we lost TV stations' commitment to truth over drama and bias. Is that something you can speak to?
Well, I do think that it actually serves the media entities, the media generally, to be very clear about when they're doing news and when they're doing something else. There are protections, constitutional protections that extend, for example, to rhetorical hyperbole, to parody, to expressions of opinion that do not extend to straight up factual reporting. And, you know, when I advise media entities about how to tell stories or how to frame issues, I try to work with them very carefully about keeping clean lines between these things. And I think the question is, all these questions have been great, by the way. But you know, it's a great question, and I think embedded in it, there is an apt observation, which is that there was a point. People argue over when exactly it happened, but that there was a point when television news shifted toward a more, or where the line was blurred between classic news programming and entertainment. Mm-hmm. And a number of shows have been identified, or programs have been identified as contributing to that blurring factor. And I think that is a cause. I think that is a legitimate cause for concern. I don't think that it contributes significantly to the greatest problems that we have today. And I think that was actually a problem that existed within the Republic for a fairly long time. Mm-hmm. So it's certainly a concern, but in terms of what are the big things that keep me up at night worrying about the future of the country and the future of free speech, although that's a legitimate concern, I don't view that as one of the sort of the big movers in the change that we're seeing now.
Mm-hmm. Okay. I'm looking here. Well, here's a related. Are we able to regulate the sharing of untrue information on the internet?
So here's the. So it's another great question. So there's a practical obstacle and there's a legal obstacle. The legal obstacle primarily lies in Section 230 of the Communications Decency Act, which essentially means that if I'm a simple user of an online service and all I do is share information, then there's one reading of the Section 230 that basically says I probably can't be held liable for that, so forth and so on.
Right.
And you know, my sense is that we probably don't want to change that law. You probably want to be able to share information on the internet without having to do your independent research into whether this, you know, New York Times story is right or not.
All right.
So I think that you know, that being able to do that is that's very hard to fix through regulation. You know, but the initial sharing of information, you know, Nicholas Sandmann, the young man who was at the rally in Washington, D.C., wearing the MAGA hat, where there was the video that went viral of him sued multiple media entities who were among the first ones to put out the video that he said portrayed him in a false way. He sued them. The terms of the settlements have not been disclosed, but he settled with two media entities over that. So, in certain cases, you may be able, if you're the harmed party, to sue the part. You may be able to sue the party who did the initial distribution, but you probably won't be able to get at every sharing of that online. But as a practical matter, you wouldn't want to, in all likelihood, anyway. At some point you're going to run out of collectible defendants. It's not going to be worth the amount of time that you're spending on it. But to the extent the question is simply, we've got lots of people out there sharing false information and we don't know how to stop it. That's exactly right. That's exactly true. And the mechanisms that are available for stopping it in our current legal structure are actually very, very few.
Yeah. Okay. Karen wants to know what happened to laws on slander and libel. How did they affect the First Amendment?
Yeah. So until 1964, basically the Supreme Court didn't seem to think that libel or slander had anything to do with the First Amendment, that it was simply a category of speech that was excluded from the First Amendment. And we know there are lots of categories of speech that get no First Amendment protection at all. Blackmail is a form of speech, but it's not protected by the First Amendment. Extortion, threats, these are things that are speech, but they're not protected by the First Amendment. So for many years, up until 1964, the court more or less proceeded on the assumption that that was just outside the First Amendment. The First Amendment didn't worry about it at all. But what became clear by 1964 was that some public officials were using libel and slander in order basically to suppress political speech. And particularly in the South, there was a program to, in essence, try to chase the New York Times and other media entities from the Northeast out of the South by bringing libel and slander actions against them. And so in New York Times versus Sullivan, the Supreme Court made it harder for public officials to bring those cases. They can still bring them, but the burden of proof that they have is higher. Later case from the Supreme Court said basically that extends to public figures as well. People who are either have thrown themselves into a controversy in a very public way, or people who are just general purpose public figures, people like Oprah, who really sort of have the same kind of voice publicly as do public officials. So there was a very, in the 1960s, we get this very significant change. It doesn't change libel and slander law, as it applies to non-public officials and non-public figures, or at least doesn't change it very much. Teresa, if at the end of our remarks today, you said, I want to thank Len Niehoff for joining us. It's a shame that every morning he drinks 2 bottles of scotch and eats puppies for breakfast. I could sue you for I'm not a public official, I'm not a public figure, it's false, it's defamatory. I'm sure my reputation would be ruined with everyone here, especially about that puppy part there. Large parts of that doctrine are still available. There's still available remedies. The reason we think that they don't play a very major role, though, is because they don't help public officials or public figures very much. And those are the lawsuits we would tend to pay attention to. So those laws are still there. They just don't play a very significant role for the most part with public officials and public figures. There is one case that I think is still scheduled to go to trial, a case brought against the New York Times by Sarah Palin that may well be the exception, maybe one of those rare cases where we see a public official bring a case against a major media entity that actually goes to trial. So that may go to trial unless we see it settled. But for the most part, we just don't see those cases get very far because the standard is so high.
Okay, thank you. We're running close to time. I want to ask you 2 kind of big questions before we go. You mentioned Section 230, of the Communications Decency Act of 1996. This is in the news lately. Both Trump and Biden have brought up this Section 230, and it would be a great public service for you to explain to people what the heck it is and what people are arguing about.
Yeah. So this is hard to do. This is hard to do quickly, but I will.
Yeah, I know. I'm sorry. I
No,
apologize.
it's okay. It's really very important, and if I can be helpful here, I want to be. So let me start here. So in order to understand what Section 230 is about, you have to understand what the world looked like before the internet. Before the internet, you would be held liable. You could be held liable, sued for something that you said, right? That you published. You could also be, under certain circumstances, held liable for information you distributed, right? There was this thing called distributor liability. So we had publisher liability, distributor liability. So we had all these models sort of pre-internet about when is somebody liable for information that goes through their hands. When the internet comes along and we get platforms, like say, for example, Facebook, okay? So the question now, we look at Facebook and we say, well, what is that? Is it, if I put content up on Facebook, then is Facebook publishing that? Are they as liable for it as if they had written it themselves? Are they just like a distributor of that information? How do we think about that? And there were some early cases that essentially suggested that online platforms would be liable for whatever appeared on them. And this created all sorts of problems. One problem was that it actually, if you had an online platform and you were trying to make it look like you weren't the publisher, one of the things you'd be disinclined from doing is editing or taking anything down. So if you had an online platform and somebody put content up there, for example, that was defamatory or pornographic or whatever, you were kind of in a double bind. If you left it there, you might be liable for it. But if you took it down, it suggested that you had been the publisher, and so you were liable for whatever damage it did when it was up. So this was all very, very complicated. There was this big elaborate law called the Communications Decency Act, most of which has been held unconstitutional, that was adopted really for purposes of trying to keep pornography out of the hands of children. That was the overall purpose of the Communications Decency Act. But tucked away in the statute was this Section 230, which basically said that if you are an internet service provider and a third party posts content on your platform, you can't be held liable for that. So, ironically, the greatest beneficiary of this is President Trump. You know, Twitter allows President Trump to post all the horrible things that he says about people there because Twitter can't be held liable for it. It can't be held liable under Section 230 of the Communications Decency Act. If Twitter could be held liable, then what Twitter would do is it probably would have terminated President Trump's account long ago. So one of the ironies here with President Trump saying, I want to have amendments to the Section 230, is he's been in many ways, probably one of the biggest beneficiaries of Section 230. Now, the reason there's a big debate about this is that there are two reasons. The first reason is it results in some real weird kind of results. For example, Teresa, if you wrote a letter to the Wall Street Journal, letter to the editor, and it defamed me, and the Wall Street Journal published it in its print edition, I could sue the Wall Street Journal for publishing your defamatory content, right? And Section 230 wouldn't say anything about it because it's not an online publication. But now think of the online version of Section 230. You know how people can make comments on articles? Let's say you go there and you make exactly the same comment on their platform. Now, I can't sue the Wall Street Journal because Section 230 protects it. So you end up with these kind of anomalies, right? That are really hard to justify and hard to explain.
Got it.
So one of the concerns here is that. The bigger concern is that essentially, look, take for example a revenge porn site, where there's a site where the site doesn't generate any of the content itself. It's just misogynistic creeps who want to post, revenge porn against women who they, from whom they've broken up, and they want to post this stuff. Now, if you look at Section 230 and you read it literally, the victims of that revenge porn can't sue the revenge porn site because they're not generating the content, right?
Right. They're just a host.
They're just the host.
Right.
And it may be completely unrealistic for them to try to figure out how to sue the individual, right? Because that person may be uncollectible. They may have no resources. They may not know where that person lives. That person may live in another state. So you can imagine in a case like that how somebody might be left remediless. Here they have this horrible thing floating around outside the internet, invading their privacy, causing them real pain, and there's no apparent solution to it. The problem with Section 230, and the reason it's such a really problematic sort of political football, is that there's no easy, obvious fix to the problems that Section 230 presents. We all have this love-hate relationship with the internet, right? We hate the way it functions, and we love the way it functions, right? And the minute our use of it is changed, none of us are going to be happy. And so what we have are politicians trying to figure out, is there a way, legislators trying to figure out, is there a way to solve the things that are the biggest problems with Section 230, but that don't so fundamentally change the internet works that people will be outraged by the consequences.
Got it. Okay. Okay, so I have like 17 more questions, but we're out of time. So I'm just going to ask you one more, and it's a big one too, but just try to give us like, I don't know, 3 bullet points. You have done a great job of complicating the questions for us. But we can't walk away hopeless here. One of the hallmarks of the current situation is that speech is being suppressed by speech, in a sense. The flood of hate speech is just, as I said in the intro, many people are just walk away disgusted because it feels impossible to counter. So we can't, what 2 or 3 things, what 2 or 3 remedies are there to prop up or repair the crashed marketplace of ideas?
Yeah, so I wish I had a quick, easy, cheerful answer to that. One of my favorite writers is a guy named Kwame Anthony Appiah, who you might know. He's a professor of philosophy. I think he's at NYU now. And he tells the story about how whenever he's on an airplane and the person next to him turns to him and says, "What do you do?" And he says, "I'm a philosopher." They always ask the same next question, which is, "What's your philosophy?" and he always says the same thing, which is he says, "My philosophy is that everything's more complicated than you think it is." To some degree, that's my philosophy too. And it's what I do as a law professor. But I appreciate the fact that you have to come out of the other end of it with something that sort of gives you hope,
right?
And
something to do.
And something to do. And so what I want to say is that basically I see the solutions to this as lying in the following mechanisms. Number 1, supporting financially the voices that you care about. In the current regime that we're in, if you're not supporting the political candidates, the political causes, the political organizations, the media, if you are not supporting the entities that you care about with your cash and whatever you have to donate, then you are not participating in the marketplace of ideas.
Okay.
And so I think that's number 1.
Okay.
I think number 2, accepting our own individual responsibility, watching what we repeat, watching the messages that we amplify and the voices that we amplify, promoting thoughtful dialogue in whatever ways we can. Third, being supportive of educational efforts to build civil dialogue around difficult issues, and doing everything we can to support that. So much of what we see going on now is just bad critical thinking skills. It doesn't so much have to do with speech, it has to do with the quality of the thinking that the speech reflects.
Right.
So being champions for education, supporting educational efforts in that regard are critical. Fourth, recognizing the fact that free speech falls more heavily on some people than others, and recognizing that we need to be supportive of all those populations that bear the brunt of the hard parts of our free speech doctrine. There are wonderful parts to it, but hard parts as well. And the final thing is this. One of my favorite opinions in the free speech area was written by Justice Louis Brandeis. And in the opinion, he sort of goes through all the reasons we protect free speech. But if you go through and you look at this beautiful text that he's written, this is a case called Whitney versus California. It's a concurring opinion of his. The word that jumps out at you over and over again is courage. And he says, look, the people who created this country, the people who framed this Constitution, they were not cowards. They were not afraid. And fear makes us do terrible things. And he has this wonderful line, men feared witches and burned women, right? And the message I think that comes from Justice Brandeis is, look, this requires us to be brave. And there's no shortcut for that, and there's no substitute for that. And one of the things I think is terribly important to recognize about that is Justice Brandeis was not speaking from a perch of complete privilege. Justice Brandeis was Jewish, and on the court, he experienced horrific anti-Semitism, including by his colleagues, one of whom would leave the room when Brandeis walked in because he did not want to be in the same room with the Jewish justice.
Wow.
So when Justice Brandeis said, this requires courage, he knew what he was talking about. He knew the amount of courage that it requires. And look, what do we all have to have right now in the current situation in which we find ourselves more than anything?
Yeah.
That's what we have to have.
Yeah.
End of sermon, but that's my—
Wonderful. What a great ending. Thank you so, so much. That is really was a heartening speech, and I can't wait to listen to it again on the YouTube channel. So thank you so much. Lots of kudos are coming in. Thank you for your time and for your expertise, and for the opportunity to watch this repeatedly.
Thank you very much. Thanks for having me.
Thank you very much.
Bye.
Thanks to Professor Len Niehoff of the University of Michigan School of Law for joining us tonight. Next month on November 18th, our topic will be the current state of our country legally after the election of 2020, the most consequential of any of our lifetimes. We'll be joined by Ellen Katz, a professor at the University of Michigan School of Law, to address that freighted topic. Just a reminder that the League of Women Voters is a nonpartisan voter education organization committed to providing disparate viewpoints to help voters participate as knowledgeably in democracy as possible. I'd like to thank the tech team tonight, Susan Woolley and Christine, I'm sorry, Christine, I forget your last name, and Shelley Shanfield. So thank you very much. I hope we see you next month. And thank you again, Professor Niehoff. We really appreciate your time.